Hi, my name is Sue Majoni. I'm a professor of paralegal studies at Mass Bay, and I am your real estate law professor. I wanted to take a few minutes and talk to you today about the case that I assigned for you for this week's reading, DeWolf versus Hingham Center Limited, the real estate case where there was a misrepresentation on the MLS listing. I wanted to talk about this case for a couple of reasons. Number one, I thought it's a good opportunity to talk about how the law works in the real estate environment, and also because it's a hot topic. The Massachusetts Supreme Judicial Court, the Massachusetts highest state Supreme Court, has just granted cert on this case, so it's not settled law yet. The Superior Court rendered its decision, which we'll talk about in just a minute. And then the case that you actually read was the opinion that you actually read was the appellate court's opinion, which has itself been, as I mentioned, granted cert, meaning that the Massachusetts Supreme Judicial Court is going to be looking at this case to make its final decision. All right, so let's talk about what happened earlier in this case. Before we even get to the facts, what happened legally is that the plaintiff, who was Daniel DeWolf, sued the defendants, Hingham Center Limited Realty Company, and Eileen Richardson, who is the listing broker, for negligent misrepresentation. And the defendants asked the court, the lower court, to grant summary judgment motion. Now, what's a summary judgment motion? It's simply where the defendants in this case are saying there is no case here. There's no genuine issue of material fact, and that there's no reason at all why they should even get to a trial. In order to make its decision on a summary judgment motion, the court has to look at all the facts in the light most favorable to the non-moving party, in this case, the plaintiff. And once they do that, if they do decide that there is no genuine issue of material fact, then they'll grant a summary judgment motion. And that's what happened in this case. So the lower court granted summary judgment motion to the defendants, meaning this case never even went to trial. The court said there's no genuine issue of material fact, there's no controversy that is not capable of being decided as a matter of law, and so they said that's the end of the case. The appellate court disagreed, and that's what we're going to get into. So let's talk about the facts of this case. This is it's a real estate property case that took place down in Norwell, down the South Shore. Daniel DeWolf, who is, as I mentioned, the plaintiff, wanted to buy some property to make a 6-station hair salon. And he looked at the property listed, the property in question, 123 Washington Street, and thought it looked like a good piece of property, something he would be interested in buying to build his hair salon. The property was being listed by Hingham Center, was listed by the listing broker was, as I mentioned, Defendant Richards. In the newspaper listing for this property, there was it was declared that it was zoned Business B, meaning that that the plaintiff would be able to put his hair salon on the property. And in fact, during the negotiations for the sale of the property, Defendant Richards, on a number of occasions, stated that the property was zoned Business B, meaning that it would be okay and allowable for him to put a 6-station hair salon on. There were, however, it's important to note, some disclaimers, meaning that with the MLS listing, there was a disclaimer stating that, let me see if I can find the exact language, saying that there were no representations or warranties as to the truth of the listing information, and that included the Business B zoning representation. And keep in mind that both Richards and Hingham Realty had no official fiduciary duty towards Daniel DeWolf. Daniel DeWolf was the buyer, and they represented the seller. And in fact, they were very clear that they had no duty towards DeWolf. And indeed, in the purchase and sale agreement, there was an exculpatory clause. I'm going to find the exact language if you bear with me for just a second. the exculpatory clause states that the buyer acknowledges that the buyer has not been influenced to enter into this transaction, nor has he relied upon any warranties or representations not set forth or incorporated in this agreement or previously made in writing, except for the following additional warranties and representations, in which case the buyer wrote the word none. So after all this was said and done, the property was sold to DeWolf, and lo and behold, he finds out after the transfer of deed that it was not zoned Business B, but was in fact zoned Residential B, and that he could not put his much desired 6-station hair salon on the property. So he sued. He sued for negligent misrepresentation. And in order to, and here's where we have to stop and think to ourselves, what is the law of negligent misrepresentation? What do you need to show in order to win a case for negligent misrepresentation? So here we have to look at the law. So we've just been talking about what the facts were, and now we're talking about the law, because in a legal analysis, we look at both the facts and the law. So the law states in order to win a case for negligent misrepresentation, you need to show that, the plaintiff needs to show that the defendant, in the course of business, made false representations of material fact for the purpose of plaintiff relying on it, that the plaintiff did rely upon it, and that the plaintiff was damaged. Okay, so that's the law. And in order to determine how the law applies to the facts, we have to look at the facts. So was it the course of business? It certainly was in the course of business. Was there a false representation of material fact? Yes, there was a false misrepresentation of material fact. It was materially relevant. It was important to DeWolf that this property was zoned Business B, when in fact it was zoned Residential B. Was there the purpose of the plaintiff relying upon it? And did the plaintiff actually rely upon it? Well, that's where we have this question. And the court can, for the plaintiff, that he could have possibly relied upon that decision. Excuse me just for 1 second. I'm trying to find my next set of facts right here. All right, so that's the question that the court has to look at. How do they do it? Well, like I mentioned, this is a summary judgment motion. So they look at the facts most favorable to the plaintiff, because the defendants were the non-moving party, and if they say that there is no genuine issue of material fact, there's no controversy, then the case was properly decided. Here, however, the appellate court agrees with the plaintiff and says that this case was not properly decided in the superior court, in the lower court. In fact, that there do exist material facts that need to be figured out by a jury, that this case needs to get to a trial. Specifically, they looked at the first of all, for starters, they looked at the fact that Richards and Hingham owed no duty to DeWolf, but they said that in and of itself isn't sufficient to grant a summary judgment motion. That's correct, they owed no duty, but that doesn't exclude from them the possibility that they might be liable for negligent misrepresentation. So secondly, they looked at the fact that there was this MLS listing disclaimer, and the court said that that in and of itself is insufficient to grant a summary judgment motion. Yes, there was a disclaimer, but importantly, the paperwork that DeWolf received was the newspaper listing as well as some other written representations, and that MLS disclaimer was never in those representations. So that in and of itself is insufficient grounds to grant a summary judgment motion, because if the plaintiff never knew that there was that disclaimer there, then it doesn't apply to him. Most importantly, they look at the exculpatory clause, that language in the purchase and sale agreement that says that the buyer did not rely upon any warranties or representations made by the seller. And here the court looked very carefully at the language of this boilerplate. So it's language that's fairly standard in every purchase and sale agreement, and said that because the way the language is written, that the representations, the written representations that Richards made to DeWolf were excluded from the exculpatory clause, meaning that he could, in fact, rely upon them. Now, that's the area where the dissent disagreed. So if you look carefully at the dissent, they look at that same language and say, no, 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 no. We don't think you're interpreting this language correctly. And they're looking very closely at the specific language of the contract, of the purchase and sale agreement. And this, I'm thinking, is where the Supreme Judicial Court is going to look. Because, as I mentioned, this is boilerplate language. This is in almost virtually every purchase and sale agreement that's done to some extent or another. There's some kind of language like that. So this is an important case because keep in mind, these were the seller's listing agent, and the duty was owed to the seller. And here it is, the buyer is suing the seller's agents for representations that they inadvertently made. And keep in mind that right now everything is still looking as if it was an honest mistake. There does not seem to be any sort of intent that was meant. However, if there was intent, meaning that if the seller's agent purposefully misrepresented the facts to DeWolf, then even any kind of disclaimer that was in the purchase and sale agreement would be null and void. You can't disclaim against intentional deceit. That being said, that's all the more reason why the appellate court here is saying, get this case to a jury. This case needs to be heard by a jury. This is not something that can be decided as a matter of law without a jury. So where do we stand right now? It's still up in the air. DeWolf hasn't received his money back yet. Hingham hasn't paid anything yet. The Massachusetts Supreme Judicial Court has just granted cert, meaning they're going to be taking a look at this case, maybe asking for a hearing by the lawyers to argue the case, and maybe they will decide that the summary judgment motion was properly granted and the defendants will win. Or maybe they'll decide that the appellate opinion was properly rendered, and so then the case goes back to trial. There's no decision has been made for DeWolf yet with respect to what his actual damages might be. Right now, he's just gotten a reprieve, and the case is not dead. So stay tuned, and I hope you're enjoying the class. Take care. Have a nice weekend.